Hello everyone, in today's video I will discuss with you current legal issues in news in 2022. First is Supreme Court's landmark decision on abortion. Supreme Court in a significant judgment said it is unconstitutional to distinguish between married and unmarried women for allowing termination of pregnancy on certain exceptional grounds when the fetus is between 20 to 24 weeks. For pregnancies between 20 to 24 weeks, Section 3B of Rules under Medical Termination of Pregnancy Act Amendment 2021 lists 7 categories of women. So there was an amendment brought in this Medical Termination of Pregnancies Act in 2021 in which if the fetus is between 20 to 24 weeks, then the abortion was allowed only for 7 categories of women. First was survival of sexual assault, rape or incest. B. Minor. C. Change of marital status is there due to ongoing pregnancy. So if the woman is widow or divorced. Women with physical disabilities. Mentally ill women including mental retardation. And F is the fetal malformation that has substantial risk of being incompatible with life, or if the child is born, it may suffer from such physical or mental abnormalities to be seriously handicapped. And G was women with pregnancy in humanitarian settings or disaster or emergency situation such as may be declared by the government. So basically there were 7 categories were created in this act, and only these women were allowed to abort if the fetus is between 20 to 24 weeks, but the unmarried women was not covered in any of these categories. So recently in the judgment of X versus Health and Family Welfare Department, NCT Delhi 2022, in this case now the Honorable Supreme Court has extended the right to safe and legal abortion up to 24 weeks to unmarried and single women also, saying that it is a right of every woman to make reproductive choices without any interference from the state under Article 21 and under Article 14 of Indian Constitution. So that's why it is very important, because unmarried women was covered in this act. So Honorable Supreme Court has secured the right of unmarried women also to abort when the fetus is up to 24 weeks. Next is new Attorney General of India. Senior Advocate R. Venkateramani has been appointed as the 16th Attorney General of India by President Shrimati Draupadi Murmu for the period of 3 years. And Mr. Venkateramani now will succeed K.K. Venugopalan. The first Attorney General of India was M.C. Setalvad. Next is scheduled caste quota for Dalit Muslims and Christians. So this was also seen in news recently. Several petitions are pending before the Honorable Supreme Court seeking scheduled caste reservation benefits for Dalit who converted to Christianity or Islam. So now the people who were Dalits but who converted to Christianity or Islam, they are demanding that irrespective of the religion, the scheduled caste benefit must be given to the persons who fall in this criteria of scheduled caste. Article 341 of Indian Constitution provides that the President may specify the caste, races or tribes or part or groups within caste, races or tribe which shall be deemed to be scheduled caste. So it is the President who specifies the scheduled caste basically. The first order was issued in 1950 under this provision, which covered only Hindus. Then an order was issued in 1956 including Sikhs of Dalit origin, and in 1990 the government acceded to include Buddhists of Dalit origin among the beneficiaries of scheduled caste quota. So originally in 1950 it was only Hindus. Then in 1956 Sikhs of Dalit origin were also included, and in 1990 Buddhists of Dalit origin were also included in this quota. Now the demand is there that the Muslims and Christians of Dalit origin must also be included in this. The order was revised as no person who professes a religion different from the Hindu, Sikh, or Buddhist religion shall be deemed to be a member of scheduled caste. So presently, they are not covered. The Christian and Islam Muslims from Dalit origin are actually not covered in this scheduled caste. So they are demanding this quota reservation. Ranganathan Mishra Commission was constituted in 2004. This is additional point. This commission recommended that the scheduled caste status should be completely delinked from religion, and scheduled caste should be made fully religion neutral like scheduled tribe. Because scheduled tribe is religion neutral, so the Ranganathan Mishra Commission recommended that scheduled caste quota must also be made religion neutral. In 2004, this recommendation was made. Next is the Supreme Court ordered the release of Supreme Court ordered the release of A.G. Perarivalan, one of the 7 convicts in the Rajiv Gandhi assassination case. And recently Nalini and other convicts were also released by the Supreme Court. So this is regarding that. Supreme Court bench comprising Justice L. Nageshwara Rao, Justice B.R. Gavai and Justice A.S. Bopanna upheld the delay on the part of Tamil Nadu's governor in Perarivalan pardon plea under Article 161 of the Indian Constitution, which states that the governor of a state shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. So because of the delay committed by the Tamil Nadu's governors in granting the pardon to Perarivalan, the Honorable Supreme Court has exercised the extraordinary power which is given under Article 142 of Indian Constitution. Supreme Court ordered the release of A.G. Perarivalan, one of the 7 convicts in the Rajiv Gandhi assassination case, invoking its extraordinary power under Article 142 of the Indian Constitution to exercise its special power in any case or matter pending before it to do complete justice. Article 142 of Indian Constitution states the Supreme Court in the exercise of its jurisdiction may pass such a decree or make such order as is necessary for doing the complete justice in any cause or matter before it. So, under this power of Article 142, Supreme Court has ordered the release of A.G. Perarivalan, and also recently Nalini and other convicts were released by Honorable Supreme Court. Next is the Supreme Court questioned the way Chief Election Commissioners are appointed. A 5 judges constitutional bench recently headed by Justice K.M. Joseph made the observation while considering a petition seeking a collegium-like system for the appointment of members of Election Commission, underlining various examples of Chief Election Commissioners having very short tenure since 2007. Justice Joseph said that the candidate's date of birth is known to the government, and yet they pick people who would not last the full term of the 6 years. Actually, according to the Election Commission Act 1991, Chief Election Commission will have a tenure of 6 years and or till he or she attain the age of 65 years, whichever is earlier. So this is the tenure. However, Supreme Court now had made the observation that government already know the date of birth of the candidate, and they intentionally pick and appoint such a person that he could not last for the full term of 6 years. Referring to the Article 324 subclause 2 of Indian Constitution, under which the appointment to the member of Election Commission of India are made by the President subject to the law made by the Parliament. At present, the Chief Election Commissioner and election commissioners are appointed by the President on the advice of the Cabinet under Transaction of Business Rules 1961 of the Union Cabinet. The current convention is to appoint election commissioners and to elevate them as Chief Election Commissioners on the basis of seniority. The issue is related to the likelihood of bias in the appointment, possibility of biasness conducted by the Chief Election Commissioners and election commissioners in the future. So the whole issue is around the appointment of the Chief Election Commission and election commissioners, because the government and president, basically with the consultation with the advice of the cabinet, appoint the chief election commissioners out of the election commissioners. So there are chances of a biasness in the appointment. That's why Supreme Court had made the observation that generally the government choose such people who could not complete the full term of 6 years, because they already know the date of birth of the candidates. So that's why Supreme Court was made observation that a system like collegium system, which is already used for the appointment of Supreme Court and High Court judges, such system must be used in the appointment of Chief Election Commission also, so that the process will become more transparent. So current Chief Election Commissioner of India is Shri Rajiv Kumar, who has replaced Shri Sushil Chandra. Next is Digital Data Protection Bill. This is the fourth. This is actually the fourth bill of data protection law in India. The first draft of the law, the Personal Data Protection Bill 2018, it was proposed by Justice Sri Krishna Committee. The Digital Data Protection Bill DPDP Bill to 2022 apply to all processing of personal data that is carried out digitally. This would include both personal data collected online and personal data collected offline, but is digitalized for processing. Furthermore, as far as territorial application of the law is concerned, the bill covers processing of personal data which is collected by data fiduciaries within the territory of India and which is processed to offer goods and services within India. So there are actually 7 principles of this data protection bill. Usage of personal data by the organization must be done in lawful, fair and transparent manner. Personal data must only be used for the purposes for which it was collected. Second is data minimization. Only those items of personal data required for attaining a specific purpose must be collected. Third, accuracy of personal data. Reasonable effort is made to ensure that personal data of the individual is accurate and kept up to date. Storage limitation. Personal data is not stored perpetually by default. The storage should be limited to such a duration as is necessary for the stated purpose. Digital Data Board of India. It is a new regulatory body to be set up by the government under this Act. The data protection officer appointed by data fiduciary by the companies shall be the point of contact for the grievance redressal mechanism under the provisions of this Act. And this data protection bill DPDP does not apply to the non-automated processing of personal data, offline personal data processed by an individual for any personal purpose or domestic purpose, personal data about an individual that is contained in a record that has been in existence for at least 100 years. So to these this data will not apply. Next is Honorable Supreme Court uphold the 10% EWS quota reservation, that is economic weaker section reservation, which is provided under Article 15 subclause 6 and Article 16 subclause 6. In the case of Janhit Abhiyan versus Union of India 2022, 5 judges bench by 3:2 ratio judgment held the constitutionality of this EWS quota reservation. There were three issues in this case. First was whether the 103rd constitutional amendment is violative of basic structure for providing reservations solely on the basis of economic criteria, because by 103rd constitutional amendment this EWS quota reservation introduced in Indian constitution under article 15 and 16. So first issue was relating to the constitutionality of 103rd constitutional amendment. Second, whether the amendment is violative of basic structure for excluding the poor among the scheduled caste, scheduled tribe and other backward classes categories from economic weaker section quota. And third was whether the amendment is violative of the basic structure for breaching the 50% ceiling limit. And the judgment given by the majority of the Justice Dinesh Maheshwari, Justice Belan Trivedi and Justice J.B. Pardiwala, they held that reservation structured singularly on economic criteria does not violate the basic structure of the Indian Constitution. They also held that the breach of 50% ceiling limit by EWS reservation does not violate basic structure. Okay, majority judgment given by Justice Maheshwari held that reservation is an instrument of affirmative action by state so as to ensure all-inclusive approach. It is an instrument not only for inclusion of socially and educationally backward classes. Reservation for EWS does not violate basic structure on account of 50% ceiling limit, because ceiling limit is not inflexible. Justice Bela Trivedi held that treating EWS as a separate class would be a reasonable classification. So EWS as a separate class, it would be a reasonable classification which is allowed under Article 14 of Indian Constitution, such as equals cannot be treated unequally, unequals cannot be treated equally. So treating unequals equally violates equality under the Indian Constitution. The amendment creates a separate class of EWS. The exclusion of socially and educationally backward classes cannot be said to be discriminatory or violative of the Constitution. But two judges had given the dissenting judgment, and these two judges were Chief Justice of India U. Lalit and Justice S. Ravindra Bhatt. They said that the reservation on economic criteria is per se not violative of Indian Constitution. However, by excluding the poor among the scheduled caste, scheduled tribe and other backward classes by excluding the poor among scheduled caste, scheduled tribe, other backward classes from economically backward classes on the ground they have enjoyed benefit, the 103rd Amendment practices constitutionally prohibited form of discrimination. Our Constitution does not permit exclusion, and this amendment undermines the fabric of social justice and thereby the basic structure. This court has held that Article 16 Subclause 1 and Article 16 Subclause 4 are the facets of the same equality principle. So the dissenting judgment come on the basis that economic reservation on economic criteria is per se not violative, but the exclusion of the poor from the EWS quota, that is the exclusion of SC, ST and OBC from the EWS quota, this makes it the violative of the Indian Constitution. So some additional pointers, that Article 15 and 16 Subclause 6 were added by the 103rd Constitutional Amendment. And what were the requirement given by the government for this economic weaker section certificate is you should be a general category candidate not covered under the reservation for SC, ST or OBC. Your family's gross annual income should be below rate 8 lakh annually. This includes income from all the sources as agriculture, salary, business, etc. for the financial year before you apply for the exam or for the post. Your family should not own agricultural land of size of 5 acre or more. Your family should not own a residential flat of area 1000 square feet or more. Your family should not own a residential plot in notified municipalities of an area of 100 square yard or more. and your family should not own a residential plot other than in notified municipalities of area 200 square yards or more. So if one complete all these requirements, then one can get the certificate of EWS quota. Next is D.Y. Chandrachud, sworn as in 50th Chief Justice of India by President. He was sworn in by the President Srimati Draupadi Murmu at a brief ceremony held at Rashtrapati Bhavan. Justice Chandrachud as CJI will have a term of 2 years and he will head Indian judiciary until November 10, 2024. Justice Hiralal J. Kanya, he was the first Indian Chief Justice of India who was appointed on 26 January 1950 when the Supreme Court of India was inaugurated, and the Federal Court of India came into existence on 1st October 1937, and the first Chief Justice of India of this Federal Court of India was Sir Maurice Goyer. Next is Supreme Court reiterates two-finger test ban for rape survivors. Recently, in the judgment of State of Jharkhand versus Shailendra Kumar Rai alias Pandav Rai 2022, Supreme Court reiterated the ban on two-finger test in rape cases. Supreme Court warned that the person using such test will be deemed guilty of misconduct, observing that the test was based on a patriarchal mindset that assumes that sexually active women could not be raped. The bench of Honorable Justice D.Y. Chandrachud and Justice Hima Kohli regretted that such a method of examination was being used even today. This court has time and again deprecated the use of two-finger test in cases alleging rape and sexual assault. The so-called test has no scientific basis, stating that the test re-victimize and re-traumatize the women. The court warns that this two-finger test must not be conducted, and also court ordered the state and central government to comply with this order by issuing guidelines to the hospital, private and public hospitals both. Next is Supreme Court recently gave a split verdict on hijab in educational institutions, and recently in the judgment of Eshat Shifa versus State of Karnataka and others 2022, Honorable Supreme Court gave split verdict. Justice Sudhanshu Dhulia held that there shall be no restriction on wearing hijab anywhere in school colleges in Karnataka. He said that secularity means tolerance to diversity. He said that asking a pre-university school girl to take off hijab at her school gate is an invasion on her privacy and dignity under Article 21. It is violative of fundamental right given under Article 19, Subclause 1, Subclause A, freedom of speech and expression, and Article 21, right to life and personal liberty. He referred to submission that the hijab ban has led to dropouts or transfers of students affecting their education. However, Justice Hemant Gupta held that wearing hijab is not an essential religious practice unlike the kirpan worn by the Sikhs. He also held that Karnataka's government hijab ban promotes environment favoring the equality. He said that secularity means uniformity and upheld the Karnataka's High Court ruling validating the ban. He views that hijab would affect the creation of homogeneous group of students and it would create a segmented society. He rejected the argument that denying the right to wear a headscarf also denying them the right to attend classes, as it is voluntary act of the student. He held that the adherence to uniform was a reasonable restriction on right to freedom of speech and expression. Next question is regarding legalizing the same-sex marriage. So recently in Supreme Court bench issued notice to the Centre and the Attorney General of India seeking their response to the petition which filed by the gay couples to allow them for solemnization of same-sex marriage under the Special Marriage Act 1954. So the Special Marriage Act 1954, it was enacted to facilitate the marriage of the couples who profess different faiths and preferring a civil wedding. The recent plea seek to recognize same-sex marriage in relation to this act and not under the personal laws. First petition was filed. It argued that the Special Marriage Act was ultra-vires beyond the power of the Constitution because it discriminates between same-sex couples and opposite-sex couples. It states that the act denies same-sex couples both the legal right as well as social recognition and status that come from marriage. It argued that about 15 legislations are there which guarantee the right of wages, gratuity, adoption, surrogacy, etc., but these were not available to LGBTQ plus citizens. And second petition, which was filed before the Supreme Court, argued that recognition of same-sex marriage was only a continuation of Navtej Singh Johar judgment of 2018 and the Putta Swami judgment of 2017. The petition only sought to make a 1954 Act, that is Special Marriage Act, a gender-neutral act. In the Navtej Singh Johar judgment in 2018, Honorable Supreme Court decriminalized the homosexuality and read down the section 377 of Indian Penal Code. And in the Putta Swami judgment in 2017, Honorable Supreme Court affirmed the right to privacy as a fundamental right under Article 21. Next is a remission of 11 rape convicts by the state government in Bilkis Bano gang rape case. Power of remission of state government is given under Section 432 of Criminal Procedure Code. It provides that power to suspend or remit sentences when any person has been sentenced to punishment for an offence. The appropriate government may at any time, without conditions or upon any condition which the person accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. Whenever an application is made to the appropriate government for the suspension or remission, then appropriate government may require the presiding judge of the court before or by which the conviction was confirmed to state his opinion as to whether the application should be granted or refused, together with his reasons for such opinion, and also to forward with the statement of such opinion a certified copy of the record of the trial or of such record thereof as exists. And for the section 435 of Criminal Procedure Code provide the state government to act only after consultation with the central government in certain cases. When the power conferred by section 432 and 33 upon the state government to remit or commute a sentence is exercised in any case where the sentence is for an offence investigated by Delhi Special Police Establishment constituted under the Delhi Special Police Establishment Act or by any other agency empowered to make investigation into an offence under any central act other than this code. So this section 432 subclause 2 provides that appropriate government may require the presiding judge's opinion while granting the remission to the accused person, and 435 actually provides that state government must consult the central government in cases where the investigation was done by some agency under the central act. So in this case also, in this Bilkis Bano rape case also, the investigation was done by CBI, and CBI is agency which is empowered to make investigation under the central act. So this section 435 of Criminal Procedure Code and section 432 subclause 2 are required to be complied with by the state government. So that's why it was in issue recently in the news. Next is Sedition, section 124A of Indian Penal Code, which provide the offence of sedition. That has been stated by the Honorable Supreme Court recently in the case of S.G. Wombat-Kere versus Union of India 2022. 3 judges bench of Chief Justice N.V. Ramanna, Justice Surya Kant and Justice Hima Kohli has urged the state and central government to refrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking Section 124A of Indian Penal Code. By invoking Section 124A of Indian Penal Code, why the sedition law is under consideration. So this was challenged because this section often misused. Section 124A Indian Penal Code defines sedition as an offence committed when any person by words, either spoken or written, or by signs or by visible representation or otherwise brings or attempt to bring into hatred or contempt or excite or attempt to excite disaffection towards the government established by law in India. The Constitution of India prescribes reasonable restrictions on fundamental right provided under Article 19, that is freedom of speech and expression, and reasonable restrictions are provided under Article 19 subclause 2 that can always be imposed on the right of freedom of speech and expression in order to ensure its responsible exercise. The court ruled that a statute criminalizing expression based on unconstitutionally vague definitions of disaffection towards the government, etc., is an unreasonable restriction. It is not reasonable, it is unreasonable restriction on the fundamental right of freedom of speech and expression under Article 19(1) subclause A, and it causes the constitutionally impermissible chilling effect on this fundamental right. In the year 2021, the Chief Justice of India had questions why a colonial law used against Mahatma Gandhi and Bal Gangadhar Tilak continued to survive in the law book after 75 years of independence. And Chief Justice has said that sedition or Section 124A of Indian Penal Code was prone to misuse by the government. So this was challenged, and recently in this case of SG Vombatkere versus Union of India, Honorable Supreme Court has stated this section 124A. However, in the past, constitutionality of this section 124A Indian Penal Code was upheld in the case of Kedarnath Singh versus State of Bihar 1962 by Honorable Supreme Court. Next is regarding the transfer of judges. Article 222 of the Indian Constitution deals with the transfer of judges of High Court, and it states that the President may, after consultation with the Chief Justice of India, transfer a judge from one High Court to another for better administration of justice. The current procedure for the transfer of High Court judges is the proposal for transferring a High Court judge, including a Chief Justice, should be initiated by the Chief Justice of India, and the consent of the judge is not required. All transfers are to be made in the public interest. For transferring a judge other than the Chief Justice of India should take the view of the Chief Justice of the court concerned, as well as the Chief Justice of the court to which the transfer is taking place. The views expressed in writing should be considered by full collegium of 5, that is the Chief Justice of India plus 4 senior-most judges of the Supreme Court. Then this recommendation is sent to the Union Law Minister, and who forward it to the Prime Minister, and the President gives the approval for the transfer. However, recently it was in news what makes this transfers controversial. The public feels that there is a punitive element behind the decision, and as a matter of practice, the Supreme Court and the government do not disclose the reason for the transfer. The power of transfer has always been seen as a possible threat to judicial independence. So these are the real issues, and very recently the lawyers raised the matter of transfer of a Gujarat High Court judge to the Chief Justice of India, citing rumors that the Gujarat High Court Chief Justice was uninformed of the impending transfers. So basically the issue relating to transfer of High Court judge was that even the consent of the judge is not taken for the transfer being made. Next is 22nd Law Commission of India and the new head of this 22nd Law Commission of India is Justice Ritu Raj Awasthi. 21st Law Commission was headed by the former Supreme Court Judge Justice B.S. Chauhan. Law Commission of India is a non-statutory body that is constituted by a notification of Government of India with definite terms of reference to carry out research in the field of law. The Commission makes recommendation to the government in the form of reports as per the term of reference. The Law Commission was first constituted in 1955 and its chairman was M.C. Talwad. The first commission was establishing during the colonial rule in India by the East India Company was under the Charter of 1833 and it was presided by the Lord Macaulay. I hope all this information will help you in your exams, and if you find this helpful, so give it a thumbs up, share it, and also comment. So thanks for watching and subscribe for more such relevant videos.